So what are we learning? We're learning about the process by which you have to undertake from the moment when a client sees you through till the end of their case, file, matter, whatever you want to call it. So you'll see me draw lots, and I mean, when I say lots, I mean like you'll get sick of me drawing it. Timelines. So I might put here C for client, for example. So when you first see your client, through to say, for example, you might put H for hearing. Okay, so the first time when we see our client through to when we have a hearing, and you might say, well, look, there's a number of things we have to do in that process to get that outcome. We also might change though. We might say, well, actually, the hearing's not what's important because we don't actually have an outcome at that particular point. What we might be saying, most of our claims, not all, but most of our claims are about money. We're suing for money. So we might say, for example, it's from when we see our client through to when we get the outcome for our client, perhaps. Anyway, however you want to put what that end point is, that's what we're here to learn. We're here to learn what you need to do from when a client walks through your door, phones up with a new matter, and what processes you need to undertake throughout that in order to get to the end state, whether it's a hearing, whether it's an appeal on that hearing, whether it's an outcome to get their money, or whether it settles at some point in the middle here. Okay, so we're going through that process. You're going to learn how to get a file from the very start through to the end. So if you walked in with any other idea about what we're learning, then that might be a bit of a shock, but that's where we're headed. So what can be really useful is a little bit of a broad overview as to what that process might look like. Now that whole process can literally take years, and ordinarily will take years. It's not unusual. So that would probably, you know, a standard file that might go through to a hearing, that's probably won't be heard anything less than 2 years. Might be more, sometimes it's lots more. So there's no set amount for that. It's however long. We'll learn what each of those different steps have in terms of timeline. But what is standard is the various parts. So you can sort of break it up, a little bit rough, but you can kind of break it up into 2 sections. So we're looking at what's called pleadings. Is that clear enough? Yeah. So my writing is inherently shocking, right? But I do try to write neat for you guys so at least you can understand it. So hopefully that's good. Pleadings, and then what's called disclosure. Really rough, okay? This isn't something that's set in stone half and half. I'm just trying to give you a bit of a rough idea. So what we're looking at in pleadings, these are the documents that go backwards and forwards between the parties, where each party, there could be a number, there might be one on each side, there might be multiple. It doesn't matter, the process is the same. It's those documents where each party puts in their version of events. I say version because there's always more than one version to every situation, and their issues. All right, so you're looking at the issues and the facts, but predominantly, let's get another colour. Okay, so predominantly we're looking at issues here. Then with disclosure, so once we've got the issues and we know what we're dealing with in terms of what each party's got a problem with, then we look at disclosure, or this assists us with the evidence. What evidence do we have in order to deal with those issues? Now, throughout that whole time, we'll be going through, throughout this, have a number of what's called applications. I suppose you might want to refer to them as, say, a mini hearing, for want of a better term. We'll learn more about these. Each of these things, the whole lecture itself. I'm trying to give you a little bit of an overview so you know where we're headed. So you might have, along the way, various applications. But the entirety of the process, from the very start here through to the end over here before you have a hearing, so the entire process is aimed at narrowing the issues. So you'll have all these issues at the start, you'll have heaps. It all depends on the matter. You'll have heaps of, the process you're aiming to have less. Because if we went to court here, with the amount of issues we started at the beginning here, each case would need months in a trial and we just don't have those sort of resources, right? And it isn't the best way to resolve it in any event. So all of our time along here is aimed at, first of all, to work out what all the issues are, so get all the issues, all the parties, all of the problems, get them all, so we've got everything all together. Then once we've got that, is to narrow the issues in dispute. So then when we get to a trial, we've only got a limited number that the parties weren't able to work out from themselves, not all of the ones we started with at the beginning. Yep. So who's seen, you know, I don't know, all the law shows, Suits and all those other cool looking ones? Yeah, we've all seen, yeah, it's cool, right? Yeah, it's not quite like that. Theirs only lasts a short matter of time, yeah? So they only ever have one file at a time. How good would that be? How they only ever have one blue folder, I think they use. They have one blue folder and it's magically resolved within, you know, a day or a week or something, and they move on to the next blue folder. Well, you're more likely, if you're in a real scenario, and for those of you in firms who will be nodding going, yes, you'll have way more files than that, tens, hundreds perhaps of files, and they're all going at the one time. So you'll talk to one client on one file, next on another file, you're trying to handle a number at one time. And so with each one of these, each one has their own timeline that, you know, like you're trying to juggle. But on each of them, it's still the same. You're trying to narrow the issues. You're trying to get to a result. And it might be, and the very vast majority will resolve, settle in some way. It might settle right here. It might even settle before you've even sued. So you might say we issued the claim and statement of claim here. You're thinking, what's that? We'll learn about that. So say we issued the claim and statement of claim there. It might settle immediately there. It might settle here as soon as we've seen the client. We might make a phone call to the other side and resolve it straight away. It could settle here. Or it might take right before court. So you're just about to go to court. In fact, you're on your way to court. And it can settle there too. It can settle any point along the way. It can even settle after you've had a hearing, but before the judgment's been handed down. Right. But most will settle at some point along the way. That's because going to trial is the fun bit. You don't get to do that often, right? You get to do all the hard bit along the way, all the paperwork. So that's what we're doing. This is a bit of a summary version of what those various steps are along the way, and that's what we're going to be having a look at. So trial, so interlocutory steps, these applications, interlocutory. Our trial is here. That's all after trial. So what do you think one of the first things you might want to have a think about? So you're seeing your client here. You're 2, 3, 4 plus years, who knows, away from a hearing over here. What do you think one of the first things might be, having a look at this list? What do you think one of the first things you might want to think about and talk about with your client when you see them here? Have a crack. It's all good. Cost, absolutely. Okay, so even though it's way down the list down here, that's not the first thing I say, but it's one of the first things I talk about. Okay, and we're going to talk tonight a lot about costs. Okay, so you think about it. If you're going to spend your money, I always say to my staff that I train, think about costs with clients like it was your own money. I can tell you it makes it a whole lot easier to understand when it's your money. All right, so think about it as if it was yours, it's going to be a whole lot easier. All right, so what else are you going to think about here, even though it might not be till down here? What are you going to think about right away and ask your client about? What they're seeking. The amount of times we get clients in who, and that's one of the first things I ask, I say, so what are you hoping to achieve by coming to this? And they tell you, and you say, well, you know what? The court can't actually give you that. So and we'll learn about what claims you can make, what outcomes we can achieve, and oftentimes what they're hoping to achieve isn't something the court can offer. So we do spend a bit of time, and some of you have probably already done the course on mediation. I'm a huge advocate for mediation. I do a lot of mediations and get such good feedback and outcomes because mediation can give clients the outcomes they want. This process can only give you a handful of outcomes. And it might be what your client wants, it might not be what your client wants. So you've got to find out, so good point, you've got to find out early what it is that your client wants. So, what else? Another key one. So you're going to sue someone, so client comes to see you, they're owed $50,000 by their mate down the road, haven't paid them back. What's one of the first things you're going to ask your client? Sorry, say again?
What's money over?
Yeah, or do they have any money?
What money have they got?
Exactly, what money have they got? That's the very last point that we learn about. Execution, it's a good word, isn't it? Not really. Sounds a bit nasty. It's about, as you've probably heard people say, there's no point suing someone if they don't have any money. All that's going to happen is your client's going to spend a whole heap of money with you, which you might think is great because then your firm's making a heap of money, but at the end of the day, that's not a very good outcome for your client. They aren't going to have good words to say about you or your firm, are they? So you're starting to see that lots of the things that matter at the end in terms of when they happen, you actually need to bring them right up to the front and talk about them here and now, because they're really important in terms of if they have no money or they're not going to have any money or assets by the time you end up with your judgment, there's little to no point. And we'll go through all these things in a little bit in more detail, but these are, or you have all this in the front of your head. And this one with appeals, it's important too, because, and it kind of links in with costs, because you might say to your client, oh, look, you know, to go through this matter here from start to finish, look, it might take you, say, 3 years, and you might spend with me, you know, $30,000, we might get you the outcome you want. They're thinking, oh, yep, all right, you know, well, I can afford that. Oh, I can afford to, you know, spend 3 years of my life doing it. Yep, okay, I can do that. Then you get to the outcome here and you win. They're like, yep, you're awesome, that's fantastic. All happy days till the other side puts in an appeal. And they say, oh, you didn't tell me about that. Like, you didn't tell me that I might win and then I might have to do it all again and spend that all money again. So you've got to really warn about, sometimes you spend half of your time warning about all these things that can go wrong. It's almost trying to turn them off suing, and then if they still want to go ahead, well, really, they're really keen to do it because you're showing them all the negatives and all the things that might go pear-shaped. If they still want to proceed, well, good, they're well informed. But all those things have got to be brought up early. And, you know, bearing in mind, for those of you that haven't seen clients before, when they, you know, when they see you, invariably, it's the first law matter they've had. So they haven't had experience with lawyers and costs and litigation and that sort of thing before. So this is all very new to them. They've seen the shows on TV and it all seems very simple and they always win, so that's all good. And they don't see, like the shows never talk about fees, do they? They never talk about how much it's actually going to cost. So that's a bit of a bummer as well for someone who's got to pay money then to have that happen. And then they don't see that they can possibly lose. That's the hardest one. Okay, they can only see their version, their way that it occurred. In their mind, it's a you know, no brainer. They absolutely can't lose. Well, I can tell you after being in law practice for 25 years that even ones you thought were not able to be lost can definitely be lost, or the ones you thought you could never win can be won, because we're all human. Okay. You on your side are human, the other side is the judge, the magistrate. Okay, so you don't know what outcomes are going to come out. So you should never tell a client there is no risk with this matter. There's a risk in any matter. It could be smaller or less than others, but there's always some risk. Okay, because you're not dealing with a robot or a computer where you put in information and you get spat out a standard answer. Okay, you're dealing with humans. Humans can make errors, humans can do the right thing one day, wrong the next, not know the law, whatever. Whole heap of variables. So that first meeting, which we'll talk about tonight, that first meeting with your client is really important. It's really important on a whole heap of levels. Sometimes the first short period of time is spent trying to get a real feel and a relationship for your client so that they have faith in you that you can fix their issue, fix their problem for them. If they leave thinking, well, she's got no idea what she's doing, she's not going to be able to help me, I'm not going to go back there, well, that wasn't really time well spent, was it? Okay, so there's in that first meeting is really, really critical. Not only are you thinking about what the law is and what you've learned over the last 4 or 5 years about what the law tells you and what you're going to learn today in civil, but it's also about trying to build that relationship with your client, explain what's going to happen here, and all along here, but importantly here. And they will probably only remember 3 things. They'll remember how much you told them it was going to cost, whether they think they're going to win, and how you made them feel. That's probably it. Out of the hour or 2 hours or however long you spend with them, they probably won't remember anything else when they walk out, but they'll remember those things. So they're the things that are really important to get right. Okay. All right. How are we going so far? Everyone good? Everyone on track? Everyone's thinking, yep, this is going to be the easiest course ever. It should be. Like I try to make it so that it's nice and simple and there's no issues getting through. So hopefully I give heaps of examples, truly heaps of examples. So should all be good. So what I do in my notes, is you've seen if you've had a look already, is I've got the rules and a few other key parts in there. It's a bit of a skeleton. Then they're in Word, so if you want to type in and add extras and flesh out the notes, that's the whole purpose about putting them up the way that I have like that. And for the exam, so like you won't be tested on anything that's not in your lectures or your tutorials. So if I haven't spoken about it and I haven't talked to you about it, it's not in there. Okay, so there's never anything in there where like I'm trying to be cute or quirky and find some weird case that no, I don't do that. All right, so if we've talked about it, and truly, if you hear me talk about something over and over and over, and you'll see in some of them, you'll see little asterisks on some of my notes. Have a look at the asterisks; they're probably pretty important too. And I think some of them got more asterisks than others. They're probably really important. Yeah. All right. So, what are we going to be having a look at? We're going to use statutes, the rules, okay? Lots, please, if you do nothing else, get the rules out. Some cases, not a lot, some practice directions. Not a lot of those either. You can take the practice directions into the exam, you can take your rules and statutes, not your cases. You only need a handful of cases. This isn't one of those courses where you've got to remember like reams and reams of cases. This isn't that. You need to know your rules and have them flagged well. If you want to, even like I know some students, I've seen it all when I've seen the different exams, so some students like to print out all the rules for week 1 and put them in one folder and index and flag and stuff, and then get all the ones for week 2 and then do the same thing, do them all. You can do that if you want, like whatever works. Use whatever system, so long as you just follow what we've been talking about what you can and can't put on. You guys have got it a whole heap easier, I can tell you, than I had it when I was a student, because I know that's a long time ago, but when we had the rules, each court had their own set of rules, and they weren't all the same, they were all different. So we had to learn 3 sets of rules. Now they're called the uniform civil procedure rules, meaning there is one set and they're all the same for all the courts, thank goodness, because it was fairly hair-raising sometimes trying to get the right rules with different things. So that's all nice and simple. We don't cover, so the rules won't cover all jurisdictions, so it won't cover commissions and tribunals. It's the courts, all right? So that's where we're dealing with. Let's look at our first rule. Dun-dun-dun. Rule 5. Rule 5 is philosophy. All right, I'll give you a second to have a quick read, but this is meant to be the overarching view as to what they're trying to achieve with the rules, what the aim was. So the aim is to try to assist with the just and expeditious resolution of the real issues at a minimum of expense. Okay, so we're trying to make it just, we're trying to make it fast, with the real issues with the least amount of cost. It sounds like a great thing in theory, but it's weird noises, hey? Yeah, good, all right, it's not just me. So that sounds like a really great plan, and oftentimes it does work out that way, and then sometimes not so much. You've got to remember that in a court system, and remember what we talked about back here, that we're aiming to narrow the issues in dispute, because we can't go to the court with all the issues we started with. That's because we've got limited resources. So if we had, courts everywhere with, judges just sitting idle, waiting to hear matters, we could hear matters for longer with more evidence and more witnesses, and to make sure with more experts perhaps, and to really make sure that we got the most just and perfect outcome. But we don't have that, because we don't have the time, we don't have the resources, and importantly our clients haven't got the money to pay for that sort of system. So we need to work with what we've got in terms of resources, and to have the best and the most just outcome we can achieve for our clients with what we've got. So it's a bit of a balancing act, and that's a little bit about what Rule 5 and then what 367 talks about when I move on to the next one. So, so you see there in part 2 that the object then is for the rules to be used throughout that process, with the plan of it being with the least amount of hold up, essentially least cost and the least amount of formality. But, you know, we still get a fair amount of those, don't you worry. But the plan is to have the least amount of those so that we get outcomes for people, that we aren't stuck in the red tape, we're not caught up in costs. Will that still happen? To some extent, yes. But the plan is for it to be as less as possible. So when you start a matter in a court, so when you start with a claim, a statement of claim, or an application, don't worry, we'll come back to all those terms, you're actually undertaking at that time that you will proceed in that matter in that way. You're saying to the court, yep, when I'm filing this is how I'm going to proceed. There are sanctions if you don't. Okay, I'll leave you to read these. I don't go through many of the cases, and the ones I go through are the ones you really need for like the practical component. I put some there if you're interested in having a little bit more of a look. So we move from Rule 5 to 367, which is a bit more of, you know, the balancing part of it, where it says the court can make any order about how the matter is moving forward that it thinks fit. Okay. Now, what it's going to be having a look at, so here, for example, I'll have a look at 3. It might limit the amount of time for a trial. So you might say, one party might say, I think our trial will take 5 days. The other party will say, oh, I think it might take 4 days. And the judge might say, well, you know what, we've got 3 and we're going to hear it in 3 because I don't think we need any more than that, and make it 3. Okay, that's just an example. So you might want more, but you may not get more. Again, it's that balancing act of the time, resources, money, different things. They can limit, and this happens a lot in terms of evidence. Some people, when they're in there with their case and their witnesses, they will go on and on and on with their evidence, going over, repeating the same thing. So the judge may say, okay, you've got from 9 till 12 for all of your evidence. That's it, then we're going to have a break, and then from 1 till 4, the other side can put in their evidence. So if you haven't got everything you want in that time, bad luck. So there may be some limitations put on. So that's more of that balancing to make sure we get everything through. So we're weighing up a fair outcome, or the fairest outcome that we can achieve with the limited resources we've got. So the important, it seems to have missed the underline, but in terms of one of the important parts here is, so the court can make an order in 367, even though it may be inconsistent with another provision of these rules. So it might say, for example, that you need to do something in a certain period of time, or something to that effect. Well, the court might make an order that's, you know, different to that. Okay, so if it's an order under 367, it may be just inconsistent with another rule, or what another rule says. And that's in order. I can give you a quick example. So this Leighton one, this here, is an example of where the court won't use Rule 5 to circumvent the requirements of the rule. So, for example, in this one, basically one party was trying to get something done in a quicker time frame than what the rules required of the other party, and they said they were allowed to do that because of Rule 5, which says you need to move things along swiftly and keep things moving. So that's the reason they were using for wanting to, you know, bypass the standard time frames within the rules. And the court said, well, no, that's ridiculous. There are set time frames for a reason. You can't use Rule 5 to your advantage to circumvent the remainder of the rules. So that's an example of what that talks about. All right, case flow management. Is anyone familiar with case flow management already? So case flow, let me grab up. So there's a practice direction. So you'll see it talks about Rule 5, which we just talked about. And it's essentially a practice direction. I'll leave you to read it through yourselves. And there's even a bit of a guide to the practice direction. You can print that out too if you want. It's aimed at the courts then being able to be involved and to keep matters moving to ensure that matters don't stall or end up going so slow they never reach a finale. So we don't want matters to stall at that early point back here. So we don't want someone to get halfway and then it's just stopping, it's all too hard and we've got things in limbo. We want to either move matters forward to get them through to a hearing or a trial, or have them resolved and settled and move on, not just languishing somewhere in the middle. So the aim with case flow management is to give the courts the right and the opportunity to basically put their hand up and, write to the parties or phone and say, hey, what's going on with this one? Why isn't something happening? Look, we need to set down a time frame for this to get this thing moving, and to keep matters moving along in accordance with Rule 5, because you made an undertaking when you filed that document to keep matters moving. Yeah? So I might I'll start off talking about the lawyer's role, and then we will have a break before we move on. So the lawyer's role. What's the lawyer's role for clients? Well, ordinarily we see. Where's my notes? Ordinarily we see them first, either through their phone, emailed, dropped in off the street, whatever it might be. And then there's one main thing you need to do though before you speak to them. So those that work in firms already, what's the thing we've got to do before we can talk to a prospective client? You're making me nervous.
Conflict check.
Conflict check, beautiful. So we're checking to make sure that A, we don't already act for the other side, or B, we haven't previously acted for the other side, such that we've got information and knowledge, which would mean that we could assist the current client. Does that make sense? Let's make sure we're right with that. All right, so A walks in the door and says, I'd like you to act for me because, like my best mate has sued me and here's my claim statement claim. You go, hold on 1 second, let me just go do a check to make sure we don't already act for, okay, so his mate is B. Okay, so B's the one that's sued. B's the plaintiff. A is the one that wants us to act for them. So we will do a search of our system to make sure we don't already act for B. So let's say in a large firm especially, you might know if one of your other team members has already, perhaps it was their team that prepared the claims, or So we're doing a check to make sure we don't already act for B. And that's normally pretty quick and simple. But then you've got to also find out, not only do we act for B currently, but have we acted for B in the past, okay, so maybe last month, last year, 2 years ago, in a completely separate matter, but we gained information and knowledge about B when we acted as their solicitor, such that then with that knowledge, we could help A. Still seeing lots of blank looks. So, I'm suing you, okay, but my firm has, and my firm's acting for me, right? But my firm previously acted for you on some other completely unrelated matter, and in that matter, they helped you with your house conveyance, so they know what land you own and how much it's worth. You had to give over all sorts of documents about your income and your assets and your credit card bills and all that, so I've got access to all of that because that's what you gave them for that other matter. You also know that when they had a family law settlement that you got the boat and the antique paintings and blah, blah, blah. So, is that information going to help me in my claim in suing you? Absolutely, because I'll know, remember going back to here, I'll know there's money to be had. There's information that I wouldn't have known otherwise except for the conflict that is going to help me in my case. Okay, so lots of people just get caught up on, yes, so long as we don't currently act to the other side, it's okay. Okay, Most of the people we end up turning away because we've acted the other side previously, such that we've got information. Yeah, looking a bit better.
Is there ever a situation where you can still act where you have acted the other side?
Yeah, sometimes. Yeah. So it might be, for example, that the file that you helped them with has absolutely no relevance whatsoever to the current matter, such that any information you may have gained on that particular file is of no assistance to the person on this other one anyway. Yep. Yep. All good?